of the Act. The Equal Remuneration Act 1976 provides for payment of equal remuneration to both men and women workers for the same work or work of similar nature. So whatever may be the nature of the work, if it is being done by two people, whether male or female, based on the nature of the work, they should be paid equally. That is what it means. And coming to the commencement and applicability of the Act, it is that has so it came into force on such date, that is after 3 years of passing in the Act, and it does not define any premise or establishment or factory or industry or works. But the section 2A, it defines the appropriate garment, and 2G, the Act means that the expressions and the words which are used in this Act are not defined, but these are taken from the Industrial Disputes Act. So as such, you don't have any definitions mentioned under this particular Act. So all those are taken from the Industrial Disputes Act. So what is the appropriate garment? The garment which is, it can be the state government or it can be the central government. The man and woman means male or female human beings with above 18 years. Remuneration is the basic wage or salary or any other additional emoluments which are paid in terms of cash or kind. Same work or similar work nature, it means that whether it is male or female, if they are doing similar work, there should not be any discrimination. A worker is a person who is employed by the employer to work in an establishment. Now, what is the equal remuneration to men and women workers? No employer shall pay to any worker remuneration payable in cash or kind at the rates less favorable than those paid to the workers of the opposite sex for performing the same work. This is what the Act says. You need to pay equal remuneration to men and women if they are doing similar nature of work. And no employer should be reducing the rate of remuneration to any worker based on this. And even there should not be any discrimination while recruiting men and women. So as per section 5, whether it is men or women, there should not be any distinction at the time of recruiting the employees or subsequently you want to promote them, transfer them or train them. You should not, the Act shall not make any discrimination against women except where the woman employee is prohibited or restricted under any law for the time being in force. Okay, so but this Act does not come into the priority of the reservation. So if any reservations are there, so the Act does not interfere there. It only interferes while the recruitment of men and women in general. Now coming to the authorities and their duties, powers and procedures under the Act. So here the advisory committee you have. So the purpose of increasing opportunities for the women, the appropriate government shall constitute one or more committees to advise it regarding the extent to which the woman may be employed in such employments or establishments, and where the central government may be by specific notification can explain like what can be the criteria. Okay, so it can be the nature of work, it can be the hours of work, it can be the concern of employment or establishment, or it can be the suitability of women, part-time or any other relevant factors which the company may fit. Okay, and generally in the advisory committee, it shall consist not less than 10 persons. And authorities for hearing and deciding the claims and complaints. The labor office, the not below the labor officer rank, you have the authorities who have been having the claim to hear the complaints whenever there is anything which is arising of non-payment of wages at equal rates to men and women. Excuse me, students, I'm having a very bad cold and cough. So, little disturbances you might find. Excuse me for that. And you have the inspectors. So, who are the inspectors? The appropriate government may, by notification, appoint such persons whom it thinks fit to be as appointed as an inspector. Okay, and as I already said, under IPC section 21, he will be deemed to be a public servant and he has right to enter any premises, any building, any factory, any vessel at any reasonable time, and he might ask the employer to produce the registers, payrolls, and other documents relating to the workers. And he can also collect the evidences, and he can check the employer. I mean, he can examine the employer if or any other person who is found in charge who is connected with the premises. So he can take copies or extracts from any register or document which is maintained in the establishment. Okay. So as per section 8, it is the duty of the employer to maintain registers. Nothing can be considered. Oral cannot be considered as a material evidence. So you need to have the material documents or the registers or the papers, anything. So those have to be maintained by the employer, and it is the liability of the employer to maintain such things. And coming to the cognizance and trial of offences, no court will interfere to that of a metropolitan magistrate or judicial magistrate. So it's known, its own knowledge that upon a complaint made by the appropriate government or an officer, or a complaint made by a person aggrieved by the offense, except these two cases, there is no cognizant and trial of offense. Coming to the penalties, failure or omission to maintain any register or any other document in relation to workers employed, then you have a simple imprisonment of 1 month with a fine which might go up to 10,000 or sometimes both. You fail to omit, failure or omission to produce any register, muster roll. So muster roll is nothing but the roll of the employee which has to be maintained, or any other document relating to the employment of the workers. You'll get an imprisonment of 1 month or 10,000 fine or both. And if there is any omission or refusal to give an evidence where you prevent his agent, servant, or any person in charge of the establishment by giving the evidence, you'll have the same punishment. That is 1 month imprisonment and 10,000 fine or both. You make any recruitment in contravention of the provisions of the Act, there's an imprisonment up to 1 year, and this might be going for 3 months. And you will also have a fine up to rupees 20,000, and it might be both. Okay, so make any payment of remuneration which is not equal, unequal payment, you have the same punishment. You make any discrimination between men and women workers, same punishment. Omission or failure to carry out any direction, you have the same punishment. And omission or refusal to produce the inspector any register or document, you have the same punishment. Now, section 11 deals with the offenses by companies, where the offense is committed by a company. Every person who is in charge or responsible of a company to conduct the affairs in the business at the time of the offense was committed will be deemed to be the person for the punishment. Okay. And I mean, at the time. So even if the owner is the employer, is always punishable. But if somebody is appointed as an in charge who is objecting, or who is the in charge person who is doing all the acts, will also be liable to be punished. So coming to the miscellaneous provisions, recovery of money is due from the employer. So depending upon the decisions of an authority appointed under the act, so whatever the money has to be recovered, that will be recovered from the employer. And company, it is any body corporate, or it can be a firm or association of individuals or body of individuals. And a director, it can be in relation to a firm called as a partner. So powers of the central government is to make rules for carrying out the provisions of this act. And whatever the complaints are there, whatever the payment issues are there, whatever the misdeeds are there, those all will be taken care by the powers of the central government or the appropriate authority. So the power of the appropriate authority, I said, it can be the central government or it can be the state government, which is eligible to deal with such offences and recover the monies from the employer. And then we have the next subsection, which deals with the legislations on the social security. Here we have the first one, Workmen's Compensation Act 1923. Now, what do you mean by a compensation? Compensation is nothing but it is for the work what you are doing, you get a compensation, you get the money. Okay, that is called as wage or salary. But whenever you are working in the factory, you face anything which is not in a routine performance, some kind of an accident. It might be leading to death. Under such cases, whatever is paid is called as a compensation. So the industrial development, with the rapid increase in the usage of machines, which has given rise to a lot of industrial hazards and accidents, disablement, sickness, or death. So generally, accidents, when we're talking about, usually meaning the death or disablement. So under such cases, the legislation, the labor legislation, comes into the aid, and through which they passed the Workmen's Compensation Act 1923 in an enactment, and this was issued by the central government. So why is the necessity of this enactment? So before the enactment of the Workmen's Compensation Act, it was a very common phenomenon that the employers pay some compensation. I mean, it can be a very less amount, a meager amount, whenever the worker is having some injury, I mean, sustained some injury while he was in the duty. And it was all depending upon the companies. So a few companies voluntarily paid, few companies did not pay, which led to the industrial unrest. I mean, that was a dispute, and so many things had to be taken to the conciliation boards and the legislations, or that is the labor courts or arbitrations, to correct and to justify these issues. So even the compensation paid by some generous employers voluntarily uh, is to be very less. It's not adequate amount, and generally this compensation is paid to the family members of the deceased when a person is, I mean, when a person dies performing the act of duty in the organization, or if it is a disability, the amount will be given to the person who is disabled as a compensation. Okay, and as I said, it was a very less amount, a meager amount, which was not sufficient for the livelihood of the family members. So these were the reasons wherein the enactment said that the act should be there, wherein the act will definitely provide some kind of protection to the workmen. So initially the act was called as Workmen's Compensation Act. Now it is known as Employees Compensation Act. So it provides a social security to the employees, and whenever uh, the dependents of the employee rendered destitute by the accidents, and under such cases, this act will come in aid to protect the deceased or the what do I say, the dependents of the family members. And the act extends to the whole of India. And the applicability of the act, it applies to certain categories of railway servants, workers employed uh, uh, under specification of the Schedule 2 of the Act. And there is no age limit for the coverage of workers under this Act. But the Act does not cover the following, that is, the persons whose employment is on casual nature. It can be for the purposes of other than employers, trade, or business. And persons serving in armed forces, and the workers who are covered under Employee State Insurance Act. So, leaving these three criteria, the rest of the employees are covered under this particular act. Now, who is a dependent? So, dependent can be any of the following relatives of a deceased employee. So, who is a relative? It can be a widow of the person who died, a minor child who's a legitimate child, an adopted son. And you also define the unmarried, legitimate, or adopted daughter, or a widowed mother. If wholly dependent on the earnings of the employee at the time of his death, a son or a daughter who has attained the age of 18 years, and if wholly or in part of the dependent on the earnings of the employee at the time of his death, a widower, a parent other than a widowed mother, a minor illegitimate son, an unmarried illegitimate daughter, or a daughter legitimate or illegitimate or adopted if married and a minor, or if widowed and a minor. A minor brother, unmarried sister, a widowed sister, a widowed daughter-in-law, a minor child of a predeceased son, a minor child of predeceased daughter, where no parent of the child is alive, or a paternal grandparent if no parent of the employee is alive. All these are called as dependent. Depending upon the worker or the employee employed, you will categorize the dependents. Employee, the person who is employed with an organization, and it is a person who is employed as a railway servant and a master of a seaman or a member of a cruise ship. Okay, it can be a captain, it can be a driver, or it can be work abroad by a company, or it can be employed in any such capacity as specified in the Schedule 2. And but it does not include any person or any member who has been appointed under armed forces of the Union. And then you have the employer. So a person incorporated, a managing direct agent of the employer, the legal the legal representative of a deceased employer, or the one who inherits the estate of the deceased. I mean, he was not initially the employer, but through will, the concern has, the will mentions his name, so he has taken the estate. And any person to whom the services of the employee are temporarily lent on hire by any person. So a contractor falls within the above definition of the employer. Then you have a seaman. He can be a part of a crew of a ship. Well, what do you mean by wages? It is the privilege or it is a benefit estimated in terms of money. Wages include DNS allowance, free accommodation, and overtime pay. So, a driver of a bus, if he dies in an accident, on a claim of a compensation made by a widow, it was held that line allowance and night out allowance came under the privilege or benefit. So this can be estimated as a money. So for each individual case, the wages definition will be clearly defined and calculated. Now, disablement, it means partial or total disablement. So, partial, where you're able to do your work, uh, maybe the injury, based on the type of injury, we classify that as a partial or a total disablement. So it is partial is temporary. Such disablement only reduces the earning capacity at the time of the accident, which results in disablement. Where the disablement is of permanent nature, it reduces for all time of his earnings capacity in every employment. So the Schedule 1 contains the list of injuries which are to be deemed to be the permanent or total or partial disablement. Based on that, the compensation will be calculated. Deemed to be permanent or partial. So, part 2 of the Schedule 1 contains the list of injuries which shall be deemed to result in permanent partial disablement. And then you have Section 2, Subsection 1, Subclause 1 deals with the total disablement, which can be classified as temporary total disablement and permanent total disablement. So, total disablement means such disablement whether of a temporary or nature or permanent nature. Okay, this will incapacitate the employee for the works, for all the works which are to be performed in a factory. Now, what is the employer's liability for compensation? So, employers are liable to pay the compensation to the employees. So, what kind of compensation in case of occupational diseases? What are occupational diseases? I told you people while performing the job, if you inherently have some kind of a disease which develops because of your work done, like I told you about the cotton, whenever you're cleaning the cotton bales and so on, you have so much of dust which you inhale, which definitely disturbs the performance of your lungs and you'll have the breathing problems. So those are called as occupational diseases. So these occupational diseases have to be defined, and once it is proved that it is an occupational disease, based on that, the central government or the state government, by giving a notification in the official gazette, will describe the occupational disease and the payment of the compensation. Now, what would be the amount of compensation? The amount of compensation is payable in the event of an employee meeting with an accident. Okay. So, the Schedule 2 contains the list of persons engaged in different employments which come under the compensation. And how much is the amount payable as compensation? Where the death results due to the injury while performing the act, you die, the person dies, an amount equal to 50% of the monthly wages multiplied by the relevant factor, or 1,20,000, whichever is more, will be awarded as a compensation. And the maximum amount might go up to rupees 4.56 lakhs. Okay. And if the injury is resulting to permanent total disablement, an amount equal to 60% of the monthly wages of the injured employee multiplied by the relevant factor, or 1,40,000, whichever is more. And here, in such case, the maximum amount of compensation may go up to rupees 5.48 lakhs. And compensation to be paid when due and penalty. Now, what can be the penalty? In case where the employer does not accept the liability for the compensation to the extent which has been claimed, whatever the provisional amount based on the extent of the liability which he accepts, such payment will be deposited with the commissioner. Shall be deposited with the commissioner or made to the workman. So what does this mean? You cannot make any direct payment. Whatever the compensation is there, the employer cannot make direct payment to the employer. It is through the commissioner, whoever comes have to pay. So method of calculating wages. So every employee who has a continuous period of employment for not less than 12 months, 1/12 of the total wages which have fallen due for payment by the employer in the last 12 months will be considered for the compensation. 1/12 of the wages, monthly wages. And where the whole of the continuous period the service is less than 1 month, the monthly wages of the employee shall be the average monthly amount which during the 12 months paid immediately preceding the accident. So till the accident, before that, the 12 months period will be considered. And in any other cases, if it is not possible to calculate the monthly wages, then the monthly wages shall be 30 times of the total wages earned in respect of the last continuous period of service. Now, review of half monthly payment. So, Section 6 of the Act provides any half monthly payment under this Act, either under an agreement between the parties or under the ordinance of the Commissioner, may be reviewed by the Commissioner on the application. So, this can be either by the employer or the employee, a company can be submitting a qualified, by the certificate of a qualified medical practitioner, that they can be changed in the condition of the employee, and they might any half monthly payment may be on review, and this can be considered, and this can be converted into a monthly lump sum rather than every month, which can be converted into a lump sum payment as well. So whenever you are distributing the compensation, no compensation has to be paid in respect of an employee whose injury has resulted in death, and no payment of lump sum compensation to a woman or a person under a legal disability except by the deposit with the commissioner. So the employer cannot make payment of compensation directly to the deceased heirs, legal heirs. Okay. Now the compensation not to be assigned. So you have provided by this act, no lump sum or half monthly payment payable under this act can be assigned or charged or attached or passed to person other than the employee by operation of law. You cannot attach this to anyone. Now coming to the penalties. So if you're not if he fails to maintain a notice book, which is required under section 3 or section 10, fails to send to the commissioner a statement which is required, fails to send a report which he is required to make, or fails to make a return which is required, shall be punishable under the Act with a fine minimum amount of 50,000 to maximum of rupees 1 lakh. No, not prosecution under this section shall be instituted except by the previous sanction of a commissioner. There's no cognizance of offense. No court shall take the cognizance of the offense unless the complaint thereof is made within the 6 months of the date on which the alleged commission of the offense came to the knowledge. Okay, so if it is less than 6 months, then only the offense will be accepted. Coming to the miscellaneous provisions, you have where an accident occurs in respect of which liability to pay compensation. The powers of the commissioner are mentioned here. Where any sum has been deposited by any employer as compensation payable in respect of workman and has injured himself and finally it resulted in the death. And in the opinion of the commissioner, such sum is insufficient. I mean, he doesn't feel that the amount what you're paying as a compensation is not sufficient. The commissioner, by writing a notice in writing and by stating the reasons, he can call upon the employer with a show cause notice and ask for the claim. And if the employer fails to the show cause notice to the satisfaction of the commissioner make an award determining the total amount payable and ask the employer to deposit the same in the account. If any deficiency is there, the deficiency has to be paid. and all the costs incurred in the proceedings by the commissioner, uh, they will be subject to the rules and the discretion of the commissioner. So once the agreement has been reached, the registration of the agreement is must. If the amount is paid in lump sum or the compensation has been settled by an agreement, whether by way of redemption or any other monthly payment, the commissioner should be satisfied, and he has to maintain the genuineness and record the memorandums in a register as prescribed in the format mentioned by the authority. So an appeal shall lie to the High Court from certain orders of a commissioner as and when mentioned in the Act. So the appeal in the High Court shall be uh, done as per the amendments or as per the provisions mentioned in the Act. So the power to make the rules rests with the state government. So it has power to make the respected rules to carry out the Act. And you also have rules made by the central government, and these are laid before the parliament. And every rule which is made under this act by the central government shall be coming to an effect, okay, before the House of Parliament, and within the total period of 30 days in any one of the session or two successive sessions, and before the expiry of the session, um, the House might make an agreement or modification to the rule. Okay, so this rests with the central government, where it has to take the acceptance from the parliament. So this is what all about the Compensation Act. And we have Employee State Insurance Act. So why is this considered? We told in the earlier part that an employee who is covered under Employee State Insurance Act will not be covered under compensation. So here, if the employee or the worker is covered under this particular act, will not be covered under the Compensation Act. Okay. So the Employee State Insurance Act has come into force in the year 1948, and it provides certain benefits to the employees. Now, the moment I say insurance, insurance has comes with sickness, insurance with the maternity, insurance with the employment injury, or any provisions which are relating to the matters. So, and amendments are made from time to time based on the amendments. The Employee State Insurance Act 1948 comes into the picture. Now, why is the necessity of this act? We have so many acts which are protecting the interest of the workers and the employees. So, why this particular act especially? So, every worker is liable uh, to fall as a victim to the contingencies of life. It can be the illness, it can be the injury, it can be the death. So, in such a scenario, the affected worker may find himself unable to report to the work, and sometimes he might not be in a position to carry on his livelihood. And eventually, if he's dying early, the entire family, or I mean, the dependents, whoever are to be maintained by the worker, they all don't have their livelihood. So, to protect their interests, the Employer State Insurance Act has come into the picture. So we have the act coverage, which will be governing all the employees who are working in an establishment. Okay. So coming to the object is to provide certain benefits to the employees in case of sickness, in case of maternity, and employment injury. And the scope and coverage, the act is enacted where with every establishment where they have more than 20 employees. Okay. And their annual wage, I mean the wages, the drawing wages not exceeding rupees 15,000 per month are covered under this act. Now, the applicability of the Act, the central government is empowered to enforce the provisions of the Act by notification in the official gazette to enforce different provisions of the Act. Okay, then again we have the definitions. We have the appropriate government, which means the central government. Confinement means labor resulting in the issue of a living child or labor after 26 weeks of pregnancy, resulting in the issue of a child, whether alive or dead. Okay, so this is generally for the women who are under the maternity rules. Contribution, it is the sum of the money payable to the corporation by the principal employer in respect of an employee and includes any payment which is payable on behalf of the employee in accordance with the provisions of the Act. Corporation, it means the Employee State Insurance Corporation, which is set up under this Act. Dependent, a widow. So this we have covered in the earlier case also. A legitimate child and who has not attained the age of 25 years, or unmarried, legitimate, adopted daughter, a widowed mother. If wholly dependent on the earnings of the insured person at the time of his death, a legitimate or adopted son or a daughter who has attained the age of 25 years, and a parent other than a widowed mother, a minor illegitimate son, an unmarried illegitimate daughter, a daughter, legitimate, adopted, or illegitimate if married and minor, and if widowed and a minor, a widowed daughter-in-law, a minor brother or unmarried sister, a minor child of a predeceased son, a minor child of a predeceased daughter, a paternal grandparent. All these come under the dependents. Employment injury, it means that a person who has incurred an injury or an accident, or it can be an occupational disease, which has eventually happened in the course of employment. Employee is a person who is employed for the wages in an organization, and the wages are not exceeding 15,000 per month. Exempted employee who is not liable to pay the employee's contribution. Principal employers, these are the people in a factory, owned or occupied of the factory, includes the managing agent or the owner who occupied. Any establishment under the control of any department or if any government of or any government of India, and any other establishment or any person responsible for the supervision. Okay, so I think here I'll stop from the family definition. We'll continue in next session. Okay, thank you.